So good morning or good afternoon, wherever you are. A very warm welcome to this London International Disputes Week session entitled Arbitration and Insolvency, an Inescapable Clash of Cultures. I'm Richard Bamforth from CMS, and we CMS are delighted to be co-hosting today's discussion alongside Queen Mary University of London and Arbinsol. Traditionally, those practicing in the very separate areas of international arbitration and insolvency and restructuring are becoming increasingly aware of the existence of each other. As tribunals grapple with party insolvency and the impact of cross-border restructuring on their well-thought-out procedural calendars on the one hand, and on the other, insolvency practitioners are faced with this mysterious beast called international arbitration, in which they appear to have become embroiled without much choice, really. But as we face the economic consequences of the post-pandemic world, it seems inevitable that these challenges and conundrums will be a regular part of the day-to-day practice for those involved in both disciplines for some time to come. So we hope that today's session will be of interest to those involved in both arbitration and insolvency. It's a complex area, but we hope to be able to give you a clearer view of how the two can and should coexist. But we'll also pose some challenges on issues which are yet to be resolved in these areas. And I also know from our preparations that there are some differences of opinion amongst our panel members on some of the topics that we're going to cover. So maybe we'll have some controversy too. Let's see. But we do have a lot to get through today. So without further ado, I'll hand you over to our moderators for today, Prakhar, Chauhan and Ishaan Madaan of Arbinsol. They will introduce you to your distinguished panel and then guide you through the debate. So over to you, Prakhar and Ishaan. Thank you very much.
Thank you so much, Mr. Bamforth. Good afternoon, good evening, and good morning, everyone. Welcome to today's event. We have a stellar set of speakers today who do not need introductions to talk about a conflict which is going to play out in epic proportions in the near future. That also does not need an introduction. Though a lot has been spoken about this topic over the last year, we are going to dive deeper today to discuss the clashes, the inevitable overlaps, the dominance, the issues of primacy, and avenues of coexistence between the two fields. I'm delighted to be moderating this session with my colleague Prakhar Chauhan, co-founder of Arbinsol and associate professor at Jindal Global Law School, India. Now, I'll just make some housekeeping suggestions. All of the attendees are requested to use the question and answer button at the bottom of your screen to share your questions. Questions will be taken up towards the end of the discussion. Must I also point out as a disclaimer that views shared by the speakers may not necessarily reflect the views of any organization, entity, or firm that they may be associated with or affiliated with. Now, thank you so much for bearing with those announcements. As I mentioned, the speakers do not need introductions. If you look them up on LinkedIn or Google, you'll find pages worth of search results. So today, instead of introducing them at length, we'll ask them to share something about themselves that Google would not know. I first invite Kushal Gandhi.
Hi there, thanks very much, Ishaan. I think something that Google may not know, but some of my friends may know, is that I am what they call a mega fan of Sachin Tendulkar. I'll leave it at that.
Oh, fantastic! I'll join you at that. I move on to Felicity too.
Well, I was going to say I'm also a massive cricket fan, but I feel like I now have to think of something else. Before the pandemic hit, I decided it would be a good idea to spend my spare time doing a part-time PhD in cross-border insolvency. So now I have absolutely no spare time at all. I have, however, delighted my eldest son by going to the same university as he does at the same time, which makes him very, very happy, as you can imagine. So that's my fact.
Wow, that's fantastic. Dr. Stefan Riegler.
Yeah, my fact is again related to being a big fan of not cricket, but football. And the local football club I'm supporting is looking for a major investor. Otherwise, there may be insolvency threatening there.
Great. And now on to Dr. Stefan Riegler.
I didn't actually know that this was coming up, so I'm a little bit surprised. The only thing I can share, unfortunately, is that while in the past months I have invested some money in all kinds of tools that should help me and my body being back in shape in these difficult times, I'm afraid that most of this stuff is still untouched. So that's the unfortunate news from me.
Great. And last but not least, Dr. Vesna Lazic.
Well, thank you. I was really taken by your suggestion, and I had difficulties on thinking of anything to say, but I just, I'm going to say something very simple. I would say that a bicycle is the major and predominant, my favorite means of local transportation. So that's the only, info I would like to share with you.
Thank you so much. Thank you so much. Now, over to you, Prakhar. You're on mute.
Thank you, Ishaan. Thank you, speakers, for this interesting round of introductions. This was actually fascinating. But I'm fairly sure now Google knows all of this. So next time we probably have to figure out something else. But yeah, Sachin Tendulkar, I'm a diehard fan. To open today's discussion, may I now invite Dr. Stefan Riegler to give us a bird's eye view of what one may call as a confluence or intersection or overlap of arbitration and insolvency, and how these two disciplines have been perceived and understood over the years, and the jurisprudence surrounding it. Dr. Riegler.
Thank you very much. Let me start by thanking, obviously, the organizers of this event for having me, Lucas, Richard, Prakhar, and Ishaan. Great to be with you. It's indeed a great pleasure for me to talk about that topic that has been of particular interest to me for many, many years, the interplay between arbitration and insolvency, or as it is called for the purpose of this session, the inescapable clash of cultures. And it is, of course, a great privilege to open this session as a supporting act, so to speak, for four great speakers coming up that are truly experts in this particular field. I do have to thank the organizers, not just for having me, but also for giving me this particular part in the session, setting the scene, as it is called. I truly mean this. While setting the scene might be boring or not sufficiently challenging in other areas, when we talk about arbitration and insolvency, it is sufficiently a challenge, and I'm happy that the real issues and the core questions are actually dealt with by the four speakers that come after me. It's one thing to touch upon a certain number of topics and to raise questions and to give an overview, which is my part today, and it's a completely different story to really give answers, let alone uniform answers that might be helpful for actual cases. Before I shall briefly address some of these issues that this topic does bring about, I think it's worth recognizing the source of this so-called inescapable clash of cultures. Arbitration and insolvency are two vastly different animals. Arbitration is an autonomous, private, often confidential dispute resolution mechanism, often bilaterally between two parties with effects on these two parties only. It's based on party autonomy. It's providing a substantial degree of flexibility when it comes to procedure, and it is aimed at arriving at a result, an award that is then enforceable one-to-one for the winning party. Insolvency, on the other hand, is a centralized, a regulated procedure. It is not confidential. It's a collective procedure that is meant to resolve an issue not just between two parties, but between multiple parties. And it is seeking to protect multiple parties and thereby potentially triggering certain public policy considerations. Arbitration is somewhat delocalized, nowadays widely used cross-border. Insolvency, on the other hand, is often a purely national event with a limited territorial scope. So you can see whenever these vastly two different animals encounter each other, considerations and policies of the one face off almost opposite considerations and policies of the other. This clash of cultures has been here for many years, yet it has become a hot topic again. Why is this? Well, first, there is a certain assumption that one of the consequences of the pandemic will be an increase, if not a wave, of insolvencies. And secondly, every now and then there comes a case that sparks wider attention in literature, and we will hear about one or two of these cases later on from the speakers. So what are the issues that are actually brought about in the interplay between arbitration and insolvency? Well, it's actually a never-ending list of issues that may arise. And these issues vary very much depending on the particular circumstances of the case and a number of parameters. First of all, these issues depend on the status of the dispute at the point in time when the insolvency is commenced, or at times even on the status of the insolvency proceedings, such as when a winding up petition was submitted. So is the dispute in a pre-arbitration phase? Is a dispute pending, or has even an award been rendered? A second decisive parameter is, of course, the perspective from which one looks at these issues. Is it the perspective of arbitration, or is it the perspective of insolvency? And I can tell you already now that we will likely hear some very different views by the speakers on these topics. The arbitration perspective might be to consider insolvency as just another cumbersome obstacle on the way to get an award. The insolvency people might believe, and I'm just guessing here, that once insolvency is commenced, this is actually their show. They know how to handle an insolvency proceedings. They do not appreciate interference. They don't want one singular claimant to take money out of the estate just because this party happens to have an arbitration clause in its contract. So having these different perspectives and parameters in mind, let me give you a couple of these issues that we will hear more about later on. One of them obviously is the dispute arbitrable, and with arbitrable I mean the objective arbitrability. Is the dispute capable of being resolved by arbitration? And with the dispute I mean a dispute on a claim in the context of arbitration and not so much the insolvency proceedings as such. Secondly, what is the legal fate of the arbitration agreement that was concluded prior to the commencement of insolvency? Is it valid? Can it be terminated? What is the scope of it? Who is bound by it? And all this might be answered differently depending on the subject matter on the particular claim, because the administrator might be proactively pursuing a claim out of a contract. And the situation might be different if the estate is facing claims by a secured creditor, a non-secured creditor, out of a contract that was performed prior to the insolvency, or even out of a contract that was performed after commencement of the insolvency. And most particularly, and I'm sure we will hear a lot about this later on, an administrator might choose to pursue avoidance or challenge claims, where one might argue that this position, this kind of claim, only starts to exist with the insolvency and thereby hasn't existed before. So the question arises whether the arbitration clause can cover it, and whether the administrator might derive a position from the debtor because the avoidance claim arguably has only started to exist thereafter. Third, there is issues of capacity, subjective arbitrability regarding the debtor and the administrator. Fourth, the question is, what impacts does the insolvency have on the proceedings? Is there a stay of the proceedings? Do parties need to be changed? Does the prayer for relief need to be changed from performance into declaratory relief? That might have an impact on the content of the award. And finally, obviously, the question is, will the award be recognized and enforced, and where and how? And then obviously issues that I've briefly touched upon, such as arbitrability and public policy under the new convention, might be of relevance. having identified certain issues is an important step, but unfortunately, it's just one step. It's complex, but in addition, the next complex task or challenge is to find an answer to these questions. And that's difficult. First, I think it's fair to say that on an international level, there is hardly harmonization on how to tackle these issues. And looking at the national level and leaving aside in how far certain laws do contain explicit provisions on this interplay, most of them do not, you will find very different approaches in very different jurisdictions how to deal with the interplay of insolvency and arbitration. So you would actually have to start an analysis of what laws or even what conflicts of laws is applicable. Is it the lex arbitri? Is it the lex concursus? Is it the lex cause? And this procedure, to add a little bit of complexity, actually needs to be performed with respect to almost every single issue, every single topic that I have mentioned, because the arbitrability perspective might be a completely different one than the arbitration agreement. So the conflict of laws analysis might be different, leading you to a different law. And obviously you would have to look at the application of EU regulations or ancestral model law on cross-border insolvency and the like. I've been given the task to set the scene. I don't want to get too much involved into the presentation of my fellow speakers. Now that I have raised so many questions, I have answered not one single question. I might have confused some of you. I think it's the perfect time to hand over to the four speakers, Kushal, Felicity, Stefan, and Vesna. They will provide you with answers, and they will provide you with an insight from different perspectives, from the perspective of an advisor, of an arbitrator, and most interestingly, I think, from an arbitration perspective and an insolvency perspective. Before I hand over though, let me just conclude by mentioning, as most of you surely know, that the IBA Arbitration Committee has recently published the IBA Toolkit on insolvency and arbitration. It consists of a series of national reports, an explanatory memorandum, and a checklist quite comprehensive. If you haven't looked at it, do look at it. It's a very comprehensive piece of work. It will give you a lot of information and guidance and a lot of answers. With that, thank you very much, and I hand over to the moderators, I believe.
Thank you so much, Dr. Riegler. The stage indeed has been set. So now let's move on and dive deeper into this. I first invite Kushal Gandhi, and let's try to understand these conflicts from the perspective of a counsel. Now, Kushal, how would you advise your client in the event of, say, initiation of insolvency proceedings against the opponent, when your client specifically wants to rely on an arbitration agreement? And in this context, how do you see the recent decision rendered in the case of River Rock? And as Dr. Riegler rightly put it, how do you tame these animals?
Great, thanks very much, Ishaan. Generally, when you have an unpaid debt, an effective tool to get recovery is the threat of a winding up petition. However, this can be prevented if the debt is generally disputed. What I'm going to try and cover in the next sort of 9 minutes or so is what happens when there is a sum due from a counterparty and the underlying contract has an arbitration agreement. I'm, of course, only going to focus on the English law position. And I think the starting point is whether the creditor can present a winding up petition in relation to sums arising from an agreement which is subject to arbitration. This was analysed by the English courts in Salford Estates, which I'm sure is a decision that many will be familiar with. But just to recap very quickly what Salford Estates did, in that case, the English court held that you can have the mandatory stay provisions in Section 9 of the Arbitration Act, which enable a party to an arbitration agreement to obtain a stay of legal proceedings in respect of matters covered by the arbitration agreement. do not apply in the context of a winding up petition. However, Section 122 of the Insolvency Act confers on the court a discretionary power to wind up a company. This can then form the basis on which the court takes into account the arbitration agreement. If a debt is not admitted and falls within the terms of the arbitration agreement, that can be sufficient for the court to consider the debt to be disputed, and other than in wholly exceptional circumstances, it is not appropriate for an English judge to inquire whether the debt is disputed in good faith and on substantial grounds. What then are wholly exceptional circumstances? There was a recent decision of the English court in Telnik and Nip, which provided further guidance on what will constitute wholly exceptional circumstances. In that case, Telnik was the debtor, Nip was the creditor. It was Nip's position that there were wholly exceptional circumstances in that case which enabled the court to inquire whether the debt was genuinely disputed, as opposed to deferring the question to arbitration. In doing so, Nip relied on a few things as follows. One was that the debt was admitted, they said, in correspondence, but Telnik's position was that this correspondence was without prejudice. Telnik was anyway balance sheet insolvent. Telnik had made an unlawful distribution to its shareholders, and Telnik had tried to slow down the arbitration or failed to participate in it in good faith. Despite all of that, the court decided that wholly exceptional circumstances is a very high bar, and that there was nothing in the circumstances relied on by Nip that took the case out of the ordinary and into the realms of wholly exceptional circumstances. The court reiterated the need to avoid an investigation into whether or not the debt is bona fide disputed on substantial grounds in light of the arbitration agreement. I hope that gives you a bit of an insight into the interaction between arbitration agreements and commencing an English insolvency. I'm now going to sort of try and touch upon the English law position in the context of arbitration and commencing foreign insolvency proceedings, and to pick up your question, Ishaan, on Riverrock. Where you have an English law governed arbitration agreement or an English seat in the arbitration agreement, careful consideration will need to be given to commencing foreign insolvency proceedings that touch upon matters within the scope of the arbitration agreement. And I'm sure we'll come on to hear from other panelists as to whether or not that is right or wrong, or indeed desirable. But just to sort of recap what happened in Riverrock, because it's exactly the issue that came up in Riverrock. In that case, the English High Court granted an anti-suit injunction in relation to claims being made in foreign bankruptcy proceedings, where the underlying agreements included arbitration provisions with a London seat. To put this in context, a quick recap on the facts. The International Bank of St. Petersburg was a large retail bank incorporated in Russia. The bank was placed into provisional administration by the Central Bank of Russia in October 2018, and bankruptcy proceedings were commenced in respect of the bank before the St. Petersburg court in November 2018. The bank was declared insolvent in September 2019, and the Russian State Corporation Depository Insurance Agency was appointed as its official receiver in bankruptcy. Riverrock is an English company regulated by the FCA. Between January and July 2018, Riverrock and the bank entered into 9 substantially similar contracts. All of the contracts were governed by English law and provided for resolution of disputes by London-seated arbitration under the LCIA rules. In October 2019, and in the context of bankruptcy proceedings, the bank commenced proceedings in St. Petersburg seeking the invalidation of the contracts, relying in particular on certain provisions of bankruptcy law and civil code of the Russian Federation. Riverrock applied to the English court for an anti-suit injunction in respect of the St. Petersburg action. And again, some of you will be familiar with the legal threshold for anti-suit injunctions, but just to recap, the English court has power under Section 37 to grant of the Senior Courts Act to grant an anti-suit injunction in relation to proceedings brought in breach of an arbitration agreement, even if no arbitral proceedings have been commenced or are in prospect. The applicant must demonstrate that there is a high probability of success that the foreign proceedings are in breach of an arbitration agreement. It is then for the respondent to show a strong reason why the anti-suit injunction should not be granted. And finally, it is in the court's discretion to grant the anti-suit injunction, and in exercising that discretion, the court will have regard to whether it is just and convenient to grant the injunction. In the present case, the arbitration agreement in the contract was expressed in wide terms. It referred to arbitration claims under or in connection with, which I think is becoming the norm, at least in the contracts that I have seen, where that wide language is used for matters that are to be referred to arbitration. The English court said that there is no presumption that an arbitration agreement does not extend to claims which only arise in a company's insolvency. And again, I'm sure that this is perhaps a bit controversial, and people may not agree with that. And again, we'll come on to hear more about that. And the English court granted the anti-suit injunction. The English court was also comfortable that where the arbitration agreement provided for a London seat, arguments that the English court is not the appropriate forum to grant anti-suit relief are extremely challenging. To sum it up then from my end, for an English insolvency where a debt is governed by an arbitration agreement, it is appropriate for the court to stay or dismiss a winding up petition without investigating whether the debt is disputed in good faith and on substantial grounds. Again, that might be a controversial opinion, but that is currently the English law authority on this point. Initiating foreign bankruptcy proceedings in contravention of English law or English-seated arbitration agreements could be subject to anti-suit injunctions. Where parties enter into arbitration agreements, they will need to have their disputes determined via that forum, save in very limited and wholly exceptional circumstances. Finally, some practical considerations. If you're the claimant, where you're seeking to recover a debt that is subject to an arbitration agreement, you must consider carefully the way in which you seek to expedite your recovery. Various arbitral institutions have mechanisms in their rules for expedited proceedings and for emergency relief, which may be better suited rather than failed attempts with insolvency processes. For defendants, where a dispute is subject to an arbitration agreement, it should be possible to head off an application for a winding up petition by making clear that the debt is contested and the defendant requires the dispute to be resolved by way of arbitration. Finally, ignoring the problem will not make it go away, and equally taking drastic but misguided measures will not always result in an effective recovery. On that note, I'll hand the floor back to you, Ishaan and Prakhar.
Thank you, Kushal. Thank you very much. In fact, the discussion in Salford is very important to understand the UK perspective. And Singapore at least agrees on this one, if not the River Rock case. Last year they agreed to it. However, moving ahead, let us now hear what the insolvency expert has to say about this clash of cultures, whether she thinks it's only about the distribution on a pari passu basis or preservation of the estate, or whether she thinks arbitrations or in Richard's words, the mysterious beast has been encroaching into insolvency. And most importantly, where does she find modified universalism in all this? Felicity, please take over.
Well, I was delighted to be asked to speak on behalf of the entire insolvency universe. I think that it isn't so much about whether or not insolvency is right, because obviously it is, but how it should be used to trump arbitration. And I'd like to start by, I was actually asked to deal with the question of what to do with an arbitration award in an insolvency context. And I'll come back to that in a minute. But I saw that immediately for what it was, which was an attempt not to tame the insolvency beast, but to tame me. So I have volunteered out of the goodness of my heart to start by explaining why Riverrock is wrong. And the essential problem with Riverrock, leaving aside this question of whether transaction avoidance should be arbitrable, which it obviously shouldn't, but you can see why it is that the judge goes wrong. And I'm not going to say he's not an insolvency lawyer, neither were the people in front of him, but his explanation of what modified universalism says that modified universalism is something about distributions in insolvency estates. And he therefore says, well, therefore it follows that anything that's short of a distribution, in other words, working out whether there's some money that should come into the estate or presumably any other issue, it is not a question of modified universalism. That is a flawed premise, because modified universalism is actually something about taking the original insolvency estate and applying its effects, whatever those effects are, in the jurisdictions where the foreign insolvency is to be recognized and enforced. And that means not just distribution. This just isn't just about pari passu distribution, but it's also about all the ongoing claims in the course of it. And that's why, for example, under the UNCITRAL model law, which not as many countries have brought into force as they should have done, but we have, and so have the US and many others, that's why you get an automatic stay of proceedings under Article 21 of the model law. Because once you're in an insolvency process, and this really goes back to a point that Stefan made in opening, you are in a collective situation. And if you want to have a bilateral agreement between people where they fight, you have to remember that your insolvency estate is doing that at the expense of all the other creditors. In other words, they are footing the bill for your arbitration to run. That is why generally what happens in insolvencies is office holders make decisions about whether or not proofs of debt should be admitted, they make claims out, and they deal with the estate. And they do that on behalf of everybody. It's even more obvious in terms of inward claims. So in other words, somebody's proof of debt, are they a secured creditor? Those are plainly issues that should be determined in an insolvency and not in an arbitration. Why? Because an arbitration is private. And by very definition, the insolvency estate is not. It is a collective public event which should be binding of everybody. And if you go off to arbitration, then all the people who don't want to be bound by it will then want to re-argue the whole thing anyhow. With that as an opening point, and this is important, it's not just simply a staging for everything to be dealt with by insolvency lawyers, although obviously I take the view that that is the appropriate way for all disputes to be dealt with. But it does take into account this clash of cultures that we're talking about. And it's often quoted from the US Lines case in the US, that the tension between the two is a conflict of near polar extremes. Bankruptcy policy exerts an inexorable pull towards centralization, while arbitration policy advocates a decentralized approach towards dispute resolution. And that is where the clash comes from. Now, putting Riverrock and why it's wrong to one side, the question I was actually asked to deal with is a slightly easier question, which is what do you do when you've got your arbitration award against an insolvent party? And your insolvent party may be in a process or not yet in a process. Let's start with not yet in a process. Not yet in a process, no insolvency, no automatic stay. You can go ahead and arbitrate as you like. There's nothing that's happening in that context. You get your arbitration award, you recover it, and then later you find that this company goes into some sort of insolvency process. How does that affect you? Well, you might find that somebody tries to claw back what you've just received under your arbitration award. And that is a different question from Riverrock. We're not talking about a transaction avoidance within the insolvency. So in other words, the claim and that hasn't been arbitrated, but what to do in relation to the arbitration award that has been paid. That's an interesting question, and lots of countries deal with that question differently. Particularly English point to note is that there may be a limitation on enforcement in the new pre-insolvency process under the SIGA moratorium, A1 moratorium. There aren't a lot of moratoriums out there. I think there may have been one or two. But the payment of an arbitration award is one of the things that will be subject to a payment holiday. So in other words, if the company goes into a moratorium process, a pre-insolvency moratorium process, the award debtor won't pay the award, at least above a certain threshold, unless the monitor consents or the payment is in pursuance of a court order, which by definition arbitration won't be. So that will be an interesting question, which is what to do with arbitration awards when they interact with moratorium. The more interesting questions are what happens once the company has gone into an insolvency. And there you're looking very much more at the effect of the stay on enforcement. There, I think that the question should really be uncontroversial in almost every jurisdiction, which is once you're in an insolvency process, you don't go and grab an asset and say, that'll be mine, thank you very much. But you do, in that context, deal with pari passu distribution. And even Riverrock would say that's a question that is governed by modified universalism. So the position would be the case in the UK, certainly of a foreign insolvency or under an English insolvency. The position would be the same in the US. There's authority from the 1970s saying that that's what would happen. The position would be the same in Russia, and the same would be the case in almost all jurisdictions. And that is because you're looking at recognition and enforcement, which we know is not a question which is dealt with by the arbitration itself. So at least after an insolvency process and at least after an arbitration award, the position should be fairly straightforward in an insolvency. The interesting question, of course, is, and what happens in the Riverrock case pre-insolvency? I'm sure lots of other people will have things to say about it, and I've got another chance later to explain why you're all wrong. But meanwhile, I'll pass back to the arbitration side. Thank you.
Thank you so much, Felicity. I believe one of the battles of this war between the two universes has been triggered already. We've spoken of neopolar extremes, and of course, this war, like the Marvel and the DC universes, is going to only amplify. And but we've heard the prevailing position as it exists in the UK, and we've heard why it is incorrect. But let's, for a moment, move out of England. And as Felicity said, hear from an arbitrator's perspective. So I invite now Dr. Stefan Kroell. If you were an arbitrator in the Riverrock case with its seat outside of England, would you assume jurisdiction if approached? Why? And what would be the considerations you would take into mind?
Thank you, Ishaan, and thank you also to the organizers for having me here. I must admit, I agree with Felicity concerning the post-award stage, but with the rest, I have certain problems, and I see insolvency administrators coming with the same arguments Felicity is presenting to me now in my arbitrations as well. So let me use the Riverrock case as an example. Let's assume Riverrock had initiated the arbitration in Germany, and then the insolvency administrator of the Russian insolvency had challenged my jurisdiction due to provisions of Russian insolvency law. That is the situation which I would face or I have faced in my arbitrations. And the first question that naturally arises, shall I recognize the foreign Russian insolvency? Some of the insolvency proceedings which have been initiated, which have been giving rise to disputes, have been initiated exactly to avoid having international arbitration or international litigation in dealing with claims. For example, the famous or infamous Vivendi case was a way trying to avoid allocation of liabilities through an international process. But I think that is done today, that normally every arbitrator at least recognizes arbitration, recognizes insolvency as a fact. And the only question which arises then is, what are the consequences of that fact? And as Stefan Riegler has already pointed out, it arises, does it affect my jurisdiction? If not, does it affect the procedure I have to conduct as an arbitrator? And if I've dealt with that, does it affect the way I have to render the award? Let's look at it from the first and most important question, effect on my jurisdiction over the claim. So we heard already from Stefan that there are a number of areas where insolvency law may try to affect the jurisdiction of an arbitrator. And when you look into the various provisions and when you look into the practice of insolvency administrator, they come with three different types usually of arguments. The first one is our insolvency law explicitly excludes arbitration once we have insolvency. The second one, and that's probably the one the Russian insolvency administrator would rely on, he would say that there is exclusive jurisdiction for Russian bankruptcy courts and insolvency courts for all these questions. And also very often we hear there are public policy considerations which basically exclude arbitration due to its particular features. And whatever of the three arguments is invoked, they're usually based on three considerations. The first one is there shouldn't be any individual enforcement of claims, but it should be a centralized procedure resulting in the end in an equality of the creditors as far as the distribution of assets is concerned, the pari passu principle. And I think that is something which is inherent in all insolvency laws. Closely connected with that is that insolvency generally not only affects the two parties to an arbitration, but affects a whole group of creditors. So there is a third party involved, which is always a problem in arbitration. And the last one, which was also mentioned by Felicity, is we want to increase the overall value of the estate, and we do not want to engage in expensive arbitration proceedings which decrease the value. When you approach the problem, you have to keep three things in mind as an arbitrator. The most important part of insolvency is you want to ensure pari passu in execution, so that at the end, every creditor gets the same and there's not a single creditor who has advantage. And that necessarily involves all creditors. So everything which goes against that will probably never be accepted and should never go to an arbitrator. That means there are certain disputes, or certain procedures, for example, the extra distribution of assets are outside the realm of arbitration. They're clearly non-arbitrable. But apart from that, we have the problem that there may be a conflict and you have to engage in a balancing. Arbitration is usually just about determining whether a claim exists. It's not about executing that claim, but just whether you can participate as a creditor in an insolvency. And yes, that may have certain effects on the other creditors as well. But on the other hand, also party autonomy is part of public policy. The creditor originally agreed to arbitration, and then suddenly he may have tried to avoid this agreement by flying into insolvency. So now it's for every state or every jurisdiction to evaluate, how do we want to deal with this conflict? Do we really restrict arbitration completely, or do we just amend the procedure? And as Felicity rightly said, a majority of jurisdictions have a mandatory stay. But she didn't tell you the second part. After the mandatory stay has been set, in the majority of jurisdictions, that mandatory stay is lifted and you can go on with the arbitration proceedings after certain procedures have been followed. And that's what I would also ensure as an arbitrator. Once the insolvency administrator raises that I do not have jurisdiction, that my proceedings should be stayed mandatorily, I would ask the claimant whether the claimant has become part of the insolvency proceedings and whether the claim raised by the claimant is contested. Once it's contested by the insolvency administrator, the question then arises, is the insolvency administrator bound by the arbitration agreement entered into by the original debtor? And here in my view is, and I think that is the prevailing view, at least what I can see from my experience and from the research I've done, is that in the majority of jurisdictions, there is a general agreement that the insolvency administrator is bound by the arbitration agreement. He is or she is bound by the arbitration agreement as such. But the next question then arises, how far does the arbitration agreement go? And Riverrock discussed that as a dispute about what is the scope of the arbitration agreement. And Riverrock came with a presumption we have to interpret arbitration agreements broadly, and it also covers the disputes or the claims raised by the insolvency administrator. There, I'm not sure. I might actually agree with Felicity that this one should have gone to insolvency proceedings, and that's not part of the arbitration. And the reason why I said that, for me, it's not so much a question of interpreting the arbitration agreement. The original debtor and the creditor may have agreed on arbitrating also all these type of claims. But in my view, such an agreement would not be valid, or it would be valid, but it would not have any effect, because the original debtor has no power to give away certain rights which he or she never had. These rights arise only after insolvency has been declared, and they arise only in the person of the insolvency administrator. So that is the second point. The third point, which once I've assumed jurisdiction, let's assume for a moment I would assume jurisdiction over the Riverrock case, I would then ask myself, how does that affect my procedure? And as Stefan Riegler rightly mentioned, the first question is, who is the party now? Is it the insolvency administrator? Is it still the old debtor? Is it the estate, which may in some jurisdictions become a separate legal entity and is represented by insolvency administrator? And that's an important question, because in the end, I have to make sure that actually the new party participates in my arbitration, and this party has the chance of presenting their case. And when Felicity said there's a mandatory stay of arbitration proceedings, the country I come from, we have a mandatory stay of all court proceedings, but there's Supreme Court decisions which say there's no mandatory stay of arbitration proceedings. So it's for the arbitrator to determine whether maybe a stay is necessary to give the insolvency administrator a fair possibility to familiarize him or herself with a case, and therefore it's coming from the right to be heard, but not from the mandatory stay obligation, which does not exist in Germany. So I would probably stay my arbitration for some time to give the insolvency administrator the chance, and I would also make sure and ask in particular the claimant to educate me who is the right person who should participate in an arbitration. And then the question arises, what happens with third-party creditors who also now want to participate in an arbitration? And I'm glad that I do not have to give an answer to that one due to time restraint, because that is one of the really difficult questions there. What happens with all the other ones? Do you have to get them involved, or is arbitration just remaining between the two of them? Is the arbitration agreement extended to the other ones, or can the other ones start court proceedings? And just to give you some insight, in my thinking as an arbitration practitioner, I would say the other ones are bound by the arbitration agreement as well if they want to bring a claim. Because they claim a little bit under the head of the old debtor, and their position is resulting from the old debtor. So they can also only bring their claims in arbitration. But whether they can participate in arbitration is a second question. Let me shortly, before my time is up, come to the last question. How would that affect my procedure, and how would that affect my rendering of the award? As I said, I would stop the arbitration for some time, give the insolvency administrator time to familiarize him or herself with the proceedings, but then continue the proceedings. But in the end, I would not issue a ruling ordering payment. I would probably just issue a ruling determining that a particular claim in a certain amount exists, and that the insolvency or creditor can then go with that award, try to have it registered with the proper insolvency proceedings in the country where the insolvency are pending. And that is just a very facilitated view of that. You have a lot of other questions which might probably be addressed by Vesna, conflict of law question, characterization questions, which result a little bit from the lack of clear guidance in the statutory provisions in many jurisdictions. You mentioned we have a certain harmonization on the international insolvency level with the ancestral model law, and with the European regulation. But even there, arbitration is hardly addressed. And if it's addressed, there are considerable disputes to what extent it's really covered and what are the consequences of that. But I'm sure we will have a discussion on that in the second part. Thank you very much for the attention.
Thank you so much, Dr. Kroell. That was an amazing arbitrator's perspective, and I must say there are visible differences in approach. I mean, yes, the proof of claim point which you made is interesting. It's extremely interesting as what you would have done as an arbitrator. Now, to make it more interesting, I would love to invite Dr. Vesna Lazic and her opinion on both the aspects. I mean, that of an insolvency practitioner and that of an arbitrator, specifically with respect to the issues which are typical in insolvency proceedings, say executory contracts and avoidance clauses. And then, as everybody has been talking about, the role of the insolvency administrator. I say so because the Riverrock and the Petrovez judgments, the British Columbian judgments, are classic examples of what has been discussed. So let's hear from her and her opinion on that. Dr. Lazic.
Thank you very much, Prakhar. Good afternoon, everyone. I'm very, very glad that organizers really recognize the significance of the topic. I have only, as all of us, 10 minutes available to address many, many questions. So I will try to share my screen with you. You will find on my presentation much more slides than I would be able to possibly address, but I just felt to keep them here just for the completeness of the presentation. So I would like to address, as I said, can you see my screen? So as I said, I would like to address the question of the interaction between insolvency arbitration from both perspectives. From the point of view of insolvency law, the first question to be raised is, does insolvency law tend to impact on arbitration? And from that perspective, I think that there is no reason for treating arbitration any differently. As a point of departure for today's discussion, I would like to mention that we have pointed here to several issues that are really not kind of specific issues or some untypical issues in insolvency laws. What we are discussing here are provisions that can be found in any law on insolvency. At the beginning of the introduction of this session, it was said that, of course, they are not the same. Insolvency laws are not the same. They don't even always have underlying policies, but they do have some common denominators. And one common denominator, the most important one, is the utmost aim of these proceedings. And this is a collection and distribution of assets in an orderly manner or reorganization of proceedings. It is true that they are not the same underlying purposes, but I tend to think that insolvency laws use either the same or similar tools for achieving that aim, and these are the tools that I'm going to address in my presentation, and that we all are talking about. Every law on insolvency, I would say, has provisions on pending proceedings. Every law has provisions on how to commence proceedings on behalf or against the estate. There are provisions on the avoidance powers of the trustee. There are provisions on the executory contracts. So we don't speak about some unusual provisions in insolvency law, like automatical invalidation of arbitration clauses, which are absolutely, in my view, have no clear underlying policy in insolvency laws. So this is a point of departure, that we are discussing certain things that are really the part of a genuine law on insolvency. And indeed, arbitration as such does tend to have impact on arbitration as well. The question is how successful, how are the chances of having them really in arbitration? They are obviously going to be present in the case where the insolvency proceedings are opened at the seat of arbitration, and of course later on in the enforcement proceedings. If the arbitration is taken place outside, then it will depend, of course, on the recognition and enforcement of such insolvency proceedings. On this slide, this is the at least outline of some of those issues that are typically would arise in arbitration, except of course insolvency laws invalidating arbitration clauses, which is really rather unusual. And I would say here immediately from the point of view of arbitrators should be ignored, because there is no obvious principle of insolvency law that has been protected here. So in that case, these are really certain of points that later on also should be, in my view, considered by arbitrators. Now, what we come here, I thought I would not be talking about this because I wouldn't manage then to come to the end of my presentation, but I see that each of the speakers has addressed the question of the avoidance powers of the trustee, and this is really something that is absolutely immanent in insolvency law. They are not the same in every insolvency law, but every insolvency law knows that concept. So in majority of the comparative research that I have done, the result is here that a trustee obviously cannot be bound by arbitration agreements in such transactions, because these are causes of action that are created by insolvency laws. They are not causes of action that are inherited from the debtor. Here we have some cases from comparative law, United States, Germany, Singapore, that they have taken different view. In England, we have an interesting couple of decisions. Riverrock is the second in the line. The first one, I would say, I would absolutely recommend it as a very, very interesting reading on the analysis, in particular on the analysis regarding the anti-suit injunction in the view of the revised recast Brussels I bis regulation. But what is important to mention here, there are two important points. This case is to be distinguished from all other cases that you could see on my previous slides, because all other cases are decided in the context of insolvency courts where the insolvency proceedings were open. All these cases in England are decided regarding the insolvencies that are opened outside of England. And I'm very much convinced that should that be otherwise, and should the English courts had the opportunity to decide on whether the trustee would be bound, I'm quite sure that they would reach different conclusions than in the present case. What I think the second point to be mentioned here is, and that's the point of difficulty. Very often when asking for the annulment or exercising avoidance powers, trustee also, together with that claim, also files the claim which is inherited from a debtor. For example, nullity of the contract because of the fraudulence of the other party. So these are causes of action that he obviously did inherit from the debtor. So, and the point here is that those two should be distinguished, because in the latter case, the trustee should be bound by arbitration clause, but not in the first set of claims. The last case that is decided just a month ago by English courts is quite an illustration of what I am talking about here. In this case, it should be distinguished from previous two ones, because there was no avoidance transaction in here, because you see in paragraph 40 of this decision, it is clear that the Swiss party, opposing party in insolvency proceedings, did not object to the jurisdiction of the insolvency courts over avoidance powers. They raised only these claims that were derivative of the debtor. So, and in these cases, of course, the trustee should be bound by arbitration agreement. Now, I have a couple of minutes to switch into the question whether the arbitrators should be taken into consideration of insolvency laws. First of all, arbitrators definitely should not apply insolvency law. Arbitrators are to decide on the basis of the applicable law and on the basis of the rules chosen by the parties or determined by the tribunal. However, when exercising their duties as arbitrators, they of course have to comply with the basic principles and requirements of arbitration law. And that is that there must be a due process, that the party must be given the fair opportunity to take part in the proceedings. And secondly, of course, and very important, is that it must validly establish jurisdiction. If there is a lack of jurisdiction, of course, such an arbitral award may be set aside or refused enforcement or recognition. So considering all those important provisions of insolvency law on the position of the trustee, and considering the trustee is not free really in taking any of the actions in any proceedings, I think these are very, very important considerations to be taken by arbitrators, because the trustee may do only as much as he has given by insolvency laws. And more importantly, if the trustee exercises certain powers contrary to insolvency law and they appear detrimental for the estate, he may be held liable for such actions. And last but not the least, there are some circumstances in which the trustee would not even be permitted to take part in any legal proceedings before certain steps in insolvency have been taken. Stefan already referred to the claims of ordinary, non-secured, non-preferred creditors, which are the lowest, so to speak, rank of creditors, and that have to be treated with equality. They have to file their claims in verification proceedings, and only if they are contested, there could be any proceedings, because if they are not contested, there is no need for any proceedings, including arbitration proceedings. And it may even appear questionable in certain insolvency laws whether the trustee, without creditor participating in a verification proceedings, will be even permitted to take part in any proceedings, including arbitration. What I would like now to come to the question whether we speak really always about clash. What I would like to point here, that even in insolvency laws, even when we say arbitrators should be taking them into consideration, I just want to point out that sometimes they don't even really present some considerable limitations. That goes in particular for the pending lawsuits. Some laws, and majority of laws, would even entail automatic continuation after certain conditions have been fulfilled and after the trustee would have been put in the position to take over. So in that sense, I don't see much of a limitation. As to the affecting the jurisdiction, there are obviously some typical questions arising under insolvency law, and then they also need to be, I think, considered by the arbitrators. And also, more importantly, also with the courts deciding in the court proceedings related to arbitration when they decide on any of the matter, like avoidance powers, like we had decisions of English courts deciding on those issues. The same would be for the executory contracts. I don't really have time, as I see that I am just running out of time, to explain basics of or important things about executory contracts. But what we can see in this slide is that we have from the comparative law, we may see that there are also some kind of common denominators, I would say common trends. Acceptance of the main contract would mean acceptance of the arbitration clause as well. Unfortunately, we have this decision taken by Canadian courts that departures from this, and in the discussion, if anybody would like, we can address that. But in order to complete and to conclude my presentation, I just would conclude with the following. Certainly questions of involving questions of objective arbitrability that would affect jurisdiction of arbitrators, and in particular, public policy considerations. These are something that absolutely should be taken into consideration by arbitrators, because they are recognized grounds under arbitration laws in many jurisdictions. They are also recognizable concepts under the New York Convention. So, and again, this would be, I think, the most important point for the arbitrators to take into consideration. Absolutely not all provisions of insolvency laws, but those provisions that are really reflect the most important principles, that reflect principles of insolvency law and equal treatment of a certain category of creditors. And then I genuinely believe that in that case, we should not necessarily be speaking about any clash, but I believe that certainly the compliance with basic principles of both, I think we can achieve the aims of both proceedings. Thank you.
Thank you so much, Dr. Lazic. Now, let us just have a brief round of rebuttals for about 3 to 5 minutes per speaker before we can move to an open flow for discussion and to address questions that are coming in from the audience. I have been noting down some questions which would take into the fold that some questions that the audience have asked. So now let's begin with, my question goes out to Felicity Toube, and I will specifically point out to what Dr. Kroell said about certain issues with insolvency, one of them being that the mandatory stay can be lifted after fulfilling certain procedure. The insolvency administrator is bound by the arbitration agreement. Is that so? There are questions of public policy which should permit an arbitration to proceed, and the rights of the debtor only arise after the fact, and it's not a pre-existing debt before the insolvency actually came into effect. So Felicity, the floor is yours.
Well, obviously, those are very easy questions to answer in 3 to 5 minutes. And I speak on behalf of the Marvel universe here. I feel like I can make a demand for that, first of all. And I'll again speak from the insolvency perspective, or as I like to refer to it, the right perspective. I can propose a solution to this clash of cultures, which is that if everybody would just agree with the insolvency side, there would be no clash at all. So I feel that I could just end there. But first of all, Riverrock is an interesting case. I agree that one of the issues in Riverrock was that it was a foreign insolvency and not an English insolvency. And I also suspect the court would have reached a different conclusion. In Riverrock, it was even more interesting because it was actually a temporary administration that had finished. So this was not actually, although it was an insolvency claim, it was not a claim by an office holder. It was a claim by the bank itself. And again, it may be that that also had an effect on the way that the court came out. But ultimately, the issue here is that party autonomy is constantly overridden by insolvency as a matter of public policy and otherwise. For example, in relation to executory contracts, the provisions which say that executory contracts should automatically be terminated, for instance, by insolvency, are not part of the law of this country or of the US or of most other jurisdictions. So, for example, as of last year, if you have a clause in your contract which says it will be terminated on insolvency, that no longer works. That is void as a matter of insolvency law. If you have a contract which says on an insolvency, I will take all the assets of the company and they will be mine, those are void under the anti-deprivation principle. If you have a clause in your contract which says, I agree that on an insolvency, I will get more than all other creditors, that is void as contrary to the pari passu principle. So we always, in an insolvency context, override and in fact void clauses that people have freely entered into in their contracts. And so in that context, it's not necessarily the case that the fact that you've agreed to arbitration trumps insolvency. Why should insolvency not trump that clause like it trumps all other clauses? In relation to the stay, it is true that a mandatory stay, certainly in this jurisdiction, can be lifted. Generally, it is not lifted unless it is necessary, for example, for a fact-finding exercise. So if the insolvency office holder can determine the facts on the basis of the documents, they will determine it. There will be no lifting of the mandatory stay. And if the creditor doesn't like it, they can appeal it. It looks like a bilateral agreement and determination within the context of the insolvency. What about binding third parties by an arbitration clause? And by third parties, I also include the office holder. well, it's suggested, well, you should sort of treat them as if they are pretty much the same as the debtor. Well, that again doesn't sound like how you deal with any other contract. You don't say a contract between A and B should bind C because they're kind of in the same sort of place. So even applying contractual principles, I would say you don't necessarily bring in that arbitration clause. And then, of course, you get, even in an arbitration context, into the question of arbitrability. Well, how can you have arbitrability of an agreement between two parties which has private effect between them, but you then want to bind everybody? And in that context, I go back to the point I made earlier about the question of inward claims. I, a creditor, have a claim in this insolvency. I will prove for it, which brings up issues of submission to the insolvency jurisdiction by putting in a proof. And also the questions, certainly in this country, there's the Philpott case, which suggests that in the context of set-off, that doesn't help you get home. And the same in relation to the Bresco case in the Supreme Court. But why should it be the case that your inward claim, I am a creditor of this company, should not be determined in the insolvency like everybody else's claim? Outward claims, maybe you might view differently. So saying all of those things, I think that there are very good insolvency principles which feed into exactly how one understands contract and arbitration. And if you needed to shout about public policy, you would do that too, because insolvency has a very strong public policy behind it, which is the collective distribution. And indeed, the fact that an insolvency is, at least hypothetically, the instantaneous collection in and distribution of all the assets of the company, including those claims. So again, I would make a plea for insolvency, and I would ask arbitrators, although I am one myself and I sit on the Insol arbitration mediation colloquium, which also supports arbitration in the context of cross-border insolvency. But unless you're specifically invited, I would say arbitrators keep out of insolvency. Thank you.
Dr. Kroell, would you what would you say to that? And specifically, I mean, if I may put in a point here, how do you see do you see class arbitrations coming in somewhere? I mean, to answer inclusion of people, other creditors, can that also be justified here?
First of all, I think that's a completely different ballgame, yeah? And I wouldn't like to open that one here because then we are even moving further away. Let me address the points made by Felicity. I think, yes, there is a considerable limitation on party autonomy by insolvency law. You rightly mentioned there are certain contracts which may be terminated. There are certain things which are no longer, where party autonomy does no longer prevail. But it's always a balancing. Yeah, do you really need that? And the balancing in a lot of jurisdiction goes, at least as far as the arbitration agreement is concerned, goes the other way. Yeah, where the insolvency law says this is not an executory contract which you terminate immediately or which is terminated, or where the insolvency administrator has the decision of terminating it, yes or no. There, the balance is, we see a point that party autonomy is limited on certain areas, but it's not necessarily limited on how we deal with controversial questions of whether a claim exists, yes or no. So, and when you refer to there are no third-party bounds in other areas, it is assignment, it is heritage law, whatever. Whenever someone is succeeding someone else in a claim, that person is very often bound under contract law principles. And that is how, at least we would see in Germany, also the way of an insolvency administrator. The insolvency administrator is stepping into the shoes of the debtor. And the debtor for that particular claim, which is contested, was bound by an arbitration agreement. And there is no need to basically restrict that arbitration agreement or encroach on party autonomy, because the downsides you have on insolvency are manageable in a way. If it's contested, you can go to arbitration. And in particular, in the international scene, there is a problem that some of the insolvency proceedings may be used as a pretext of basically avoiding obligations freely entered into. And let me put one more point to Vesna. When Vesna mentioned the distinction, the difficult distinctions between, is that a claim for avoidance of a contract, or is that just a fraud claim which existed before? That is really what makes these cases so interesting, because it's very often a characterization. And I can tell you, every insolvency administrator will say that is a pure annulment case. And while the creditor wants to continue with the arbitration, will phrase the same claim as a claim of, that's a fraud claim arising under the contract. And then it really depends on the particular facts of the case, whether you have, in my view, as an arbitrator jurisdiction, yes or no. And in the interest of democracy, I suggested to Felicity to have a vote, whether insolvency arbitration should prevail in this forum here between the speakers, but she declined.
Okay, so now we've heard the perspectives of an arbitrator, we've heard the perspectives, rather the entire representation from the Marvel/insolvency universe. But now I come back to the counsel, Kushal Gandhi. Kushal, has your perspective or perception on this changed over the last 1 hour? And if so, what is it that you're looking at for your clients, hypothetically speaking?
I'm pleased to say my perspective hasn't changed on this, and just to pick up on some of the points that Felicity just made, like for example the point around contractual committee, in that, why should an office holder be bound by the arbitration agreement because they haven't signed up to it? But the reality is they're only being bound because they want to dispute what's due under the agreement. And so in the same way that if a third party was taking the benefit of the main agreement and wanted to sue under the main agreement, they would have to sort of bring their dispute to arbitration. I don't think the office holder is in that different a position. And as far as inward claims are concerned, if the claim is admitted and there's no dispute about it, there's no need to go to arbitration. So, in some respects, that's very much in the control of the office holder in some respects. And I think there's a conceptual point, which is in some respects, if the parties, when they were solvent and they entered into the agreement, decided that if there is a dispute that needs to arise about what's due under the agreement or what the rights and obligations are, they are to be determined by arbitration, then in some respects, why should that not continue when an office holder is trying to sort of say, actually, I dispute this agreement, or I'm trying to set it aside, or whatever the position may be. So I think that for me, it's the point around the fact that arbitration is no longer just a sort of sideshow. It's permeated into society a lot more. It's permeated into commercial parties thinking a lot more, and it is in its own right a respected dispute resolution forum. It's not just a sort of a commercial forum. It's actually a very well respected alternative to courts. And the other thing is, the reason why arbitration is also being encouraged in some respects is because the judiciary is overburdened. So, there are very good reasons why certain arbitration is chosen and why it should be allowed to exist and coexist with the insolvency system in some respects. So that is my perspective. And I think from a practical perspective as well, I think arbitration does have its limitations. And one of the questions that someone may ask is to say, well, what happens on enforcement? You might get through the end of the arbitration, you might get an award, but if your counterparty is insolvent and you then need to take that award and enforce it, then you might be in no better position. Well, yes, but then that's your choice to spend your time and money pursuing an arbitration in that respect, when at the end of the chain you may not be able to recover because you might end up in the insolvency process. But that's a decision that should be allowed to be made, but to the counterparties and the parties that are signed up to that agreement.
Dr. Lazic, do you agree? Do you disagree? Do you want to add?
Thank you. I just would like maybe to emphasize something that I usually speak about when speaking about insolvency and arbitration. I think there should be much more consistency in decisions taken on a similar concept. Avoidance powers, executory contracts, pending litigations, and court proceedings, these are so obvious common denominators of insolvency laws. One should really have a look at how it has been dealt in other jurisdictions in order to avoid so conflicting and confusing decisions. For example, before the River Rock case, I thought of removing avoidance powers from my presentations at all, because I thought they were absolutely no issue, and nobody would raise even the binding nature of. So in that sense, I think it is really important to, whenever the judges or arbitrators are faced, to pay a little bit attention to what has been done in other jurisdictions in order to have a little bit of at least a uniform approach in matters which are common, and with respect to which we don't have disagreeing views. The same would be on the executory contracts. This Canadian decision is unique as far as I know, where the court has held that even if the trustee accepts the contract, he doesn't have to accept the arbitration clause. It is absolutely exceptional. I've never seen any in any other jurisdiction decisions of that kind. So just to sum up, I think that exactly to concentrate on those common denominators and to look for the solutions and kind of approaches that would be acceptable for both insolvency and arbitration, so that they are complementary and not clashing. And I think that's, and another thing would be also to enhance the cooperation on international level and to recognize certain effects of insolvency proceedings in other jurisdictions. I think it is absolutely necessary now in these days. Nobody could really stick to the territoriality principle. There's certainly certain effects of insolvency proceedings should be given effect, in particular when these insolvency proceedings meet the basic requirements of the recognizing system. So that's basically everything that I wanted to add.
Recognition is indeed a big problem. Recognition needs to happen uniformly, because otherwise, it might open a Pandora's box. However, Ishaan, are we ready with the questions? I guess we have some questions here. I can see some questions in our chat box. Ishaan?
Yes, I'm particularly I've been pondering over this question. Kushal touched upon it in part. This is a question raised by Carla, and this is kind of an existential crisis, sort of an existential crisis for a creditor, at least a party to an arbitration agreement, wanting to pursue an arbitration against an entity which is going insolvent. And as Dr. Kroell said, at the end of the day, it will be a paper award. But what's the point of having a paper award if at the end of the day, you just have to stand in a long line of creditors where the major chunk of the cake would be taken by secured creditors, and you will still have to have a major haircut on anything that you might eventually end up securing for yourself. Kushal touched upon that, there is time and money involved for the creditor, but then as Felicity said, those are resources parked for the other creditors. So why should you be expending those resources on dispute resolution? So just allowing an arbitration to continue in the larger scheme of things just becomes then a theoretical exercise. Is that so? I wish to open the floor to all the speakers on this to pitch in their comments, how we can look at this and whether or not at the end of the day, it serves any practical purpose just to have a paper award, which is at the end of the day, worthless in the practical sense.
I'd love to start with this one, because this is at the heart of my concern, which is when you are looking at the question, and Kushal said, well, it's up to you if you want to bother wasting your own money on this. But as Ishaan rightly says, you're not just wasting your own money, you're wasting other creditors' monies. So if the office holder is pulled into an arbitration, which ultimately has no purpose because everybody else is going to be paid out before this person, in a way that actually is not binding anyhow on the other creditors. And in that context, the point that Stefan made about, well, it's just like an assignment. But in English law, certainly, there is no vesting of the estate in the insolvency office holder. You're not the successor in any sort of normal sense. You're an officer of the court administering the estate on behalf of the creditors as a whole. So in that context, you're a different sort of person. And those questions of priority and how things are enforced are at the heart of my concern about pointless arbitrations. Now, I might be minded to be less stroppy about arbitrations where I think there's actually a point to them. So fact-finding arbitrations where the question's got to be determined. And I absolutely agree that arbitration tribunals are as well respected as courts and should be. But just like courts don't decide all the factual questions in the context of insolvency, I don't think arbitration tribunals should either. And that's at the heart of my concern, which is you've got a paper award, what do you do with it?
Can I just jump in there, just to sort of play this out, which is in a world where businesses are becoming more international and their assets and their sort of reach is spread out. Take, for example, an English company which has assets across the world. As far as insolvency is concerned, its insolvency ought to probably start in England if it's incorporated here and has its headquarters here. But we know we don't have harmonization of insolvency across the world. And so if in the meantime, a creditor decides to start an international arbitration, gets an award before the insolvency has come to an end, and decides actually to enforce that award in a jurisdiction where there are significant assets, where the insolvency has not yet reached or received recognition, wouldn't that creditor in that situation actually have a commercial reason for pursuing that arbitration and for trying to recover? Now, I can see Felicity's gone off mute, and she might be jumping on to say, yes, but that is wrong, and why should that creditor benefit in front of other creditors? But in that respect, to the extent that creditor is benefiting, it's perhaps because the other creditors and the office holders haven't sought to get recognition for their insolvency. It's a race, and it's probably not an unjustified race, I think.
Yes, I mean, the reason why I came off mute is to say that's exactly the sort of race that you shouldn't be having in the context of insolvency, which is, as Vesna says, the concept of territorialism really has had its day. Modified universalism should lead to the effect that insolvency should be recognized worldwide. And if you're an insolvency office holder who hasn't got yourself recognized where your company has substantial assets, then you've made a mistake, because that should be the first thing you should do. So that's how you should guard against enforcement. And absolutely, from an insolvency perspective, the grab rule or the effect of territorialism is completely counter to everything that insolvency stands for. So the one thing you should not be doing is letting somebody reverse the order of priority by grabbing assets in an estate.
Prakhar, you have your hand raised.
I just had a quick question following up from what Kushal said and from what Felicity said. I mean, how do you see then, I mean, do you, Felicity, want some sort of an awareness for the arbitrators in respecting the commie and ancillary jurisdictions? How do you see that, permutation and combination? What happens if an arbitration starts in the center of main interest, and what happens if the arbitration starts in the ancillary jurisdiction, which may or may not be bound by, one regulation? So say, for instance, the ancillary jurisdiction may be outside the EU, so not the recast is not applicable, or so on and so forth.
Yes, I mean, EU it doesn't help us very much anyhow, because we in this jurisdiction have idiotically decided to Brexit. So we can't use the recast regulation in any event. But if everybody were to accept the principles behind the European regulation and behind the ancestral model law, which is that the centre of main interest should govern, then those are the principles that should govern across all jurisdictions. That is the concept of modified universalism, which Lord Hoffman described as a golden thread, which runs through at least the principles of common law, and indeed under the recast regulation underline the principles of civil law across the European continent. So the short answer is I would apply the Comey test to apply the rules of the insolvency. The interesting question is what happens if you've got a secondary insolvency, but we probably don't have time to determine that question.
Dr. Kroell, you're on mute.
Sorry. First of all, I agree with Felicity that territorialism has had its day. What we need here is this modified universalism. And I would also agree that I wouldn't like to see the race. There is a jurisdiction where I can still enforce my award, which still follows the territorialism. But in my view, that does not really change the question, should I be able to determine my claims if they're contested by the insolvency administrator in another jurisdiction? There may be reasons also for insurance questions, that you have raised an insurance or you have an insurance somewhere and you need something to prove to the insurance that there is a claim which was not fulfilled. And in the end, I think we are talking a little bit, as a professor, it always sounds odd, in the ivory tower, who is interested in getting an award if I know from the beginning that I will not be able to get any money from that award? I will only pursue my arbitration if I have the impression that either I need it for insurance purpose or whatever, or whether there is some money left. I have been involved in several arbitrations where the arbitration was stopped after one of the parties or the defendant became insolvent, because the claimant did not pursue it. Because it's costly for you as well. You have probably to pay the advance on costs. If the insolvency administrator is not participating, not paying, and in the end, you also may not be able to recover anything. So in my view is once the claimant follows on with an arbitration and the insolvency administrator contests the existence of the claim, I think Kushal mentioned that, if you have no problem with that, just admit the claim and then there would be no reason to go to arbitration anymore. You would be registered somehow. But the moment the claimant pursues the claim, I assume there is a commercial interest there. And I haven't seen in my practice, at least, someone pursuing a claim without having a commercial interest.
Great. Dr. Stefan Riegler, you set the stage, that the stage has acted out. Please, would you like to say something on this before we invite Professor Lucas Mistalis?
I was about to say these are almost the concluding words, I guess. I mean, I think Vesna's point was completely right. I mean, harmonization would be the way forward, trying to avoid contradictory decisions. And I think really that just understanding and appreciating the perspective of the other side, I was about to say, helps a lot. I do believe that there are a lot of instances and issues where insolvency could or maybe should trump arbitration, but there are instances where I think a balanced view might lead us to a different approach. Usually parties conclude an arbitration agreement not because they consider that this is a great way forward in an insolvency scenario, because they think it is a practical dispute resolution mechanism for their contract, and it might be a helpful dispute resolution mechanism for the administrator if the estate needs to pursue claims out of the contract across border, for example. So I think harmonization would be helpful in order to really avoid difficult and conflicting answers and decisions.
Dr. Lazic, any concluding words on the aspect of harmonization and the possibilities, if at all, in practice?
Thank you. I have a very, very brief comment because it just is what I already said. It is obvious that a creditor who wants to pursue further with arbitration, and with the creditor that probably did not even file the claim in bankruptcy proceedings, he has a plan, and that plan could be only to enforce that arbitral abode elsewhere on the basis, hopefully on the New York Convention, in a country where there are some substantial assets. That's obvious aim. However, again, I think the international unification on the international level, cooperation and recognition of foreign bankruptcy proceedings is an answer to that. We all know about the case law from the United States in Utrecht's case, which was in the 70s, in which the court simply stated, on the basis of committee, we are going to give effect to Swedish bankruptcy proceedings because they have similar concepts, they have similar underlying purposes as our bankruptcy law, and we are not going to enforce this arbitral award was rendered in an arbitration without participation of the trustee. So that's basically the answer, how to stop and how to, well, such creditors from depleting, so to speak, the assets on the detriment to all other creditors.
Fantastic. Thank you so much, Dr. Lazic. We now invite Professor Lucas Nestelis to please share his words of conclusion with us.
Thank you, Ishaan. I think it would be imprudent and indeed dangerous to try to summarize the words of wisdom that we have heard for the last sort of 90 minutes. Perhaps a couple of sort of broader sort of an impression sort of view of what we have heard. I think insolvency and arbitration are not new in their interaction. I mean, Stefan Riegler has been working on the topic, and Vesna and Lazic have been working on the topic for more than 2 decades. I think what we have seen is that the 2008 financial crisis and perhaps even the pandemic meant that we have more and more cases with insolvent parties, and also the way insolvency laws have developed, the different stages of insolvency. We have sort of, for example, in Italy, the example of concordato preventivo, which is not fallimento, and which the local law allows arbitration, particularly with the foreign element, to continue and up and until the insolvency starts. And again, even when the insolvency starts, it will not stop foreign proceedings. We've seen historically the conundrum of the Swiss and the UK decisions of Vivendi, and we've seen the River Rock and the new line of cases recently. And I think the broader conclusion that comes that ever since BCCI, to talk about territorial bankruptcy, it will be wrong. There's no way back. The economy is much more globalized. And I think a broader appreciation of the issues by arbitration and insolvency practitioners is critical. I think arbitrators have as a primary concern to render an enforceable award, to make an award that could be enforced. And in doing that, the key question is to establish the jurisdiction. And we see that more and more investigations are being done by arbitrators to ensure that either the insolvent party is properly represented or the insolvent party is at the stage that could still take part in proceedings. And of course, the domestic variations are critical. And I think I've heard often the word harmonization or the need for harmonization. But harmonization in Europe for some time, we had a very good sort of level of harmonization. And this has been useful in a number of cases, but the UK is no longer there, and of course we have a lot of other jurisdictions which are outside the European Union. I think it would be fair to say that all of the insights we have had from all the speakers today suggest very simply that we will continue to have that debate for some time, and it's not a matter of competition as it happened perhaps in other areas of law. It's not a competition between the EU jurisdiction and ISDS. I think both arbitration practitioners and insolvency practitioners who work in a commercial context, and I think Stefan Riegler has set out the sort of the scene very, very well, are trying to find a workable solution. Is not that it is, it's a clash of culture, but against that background, I think the attempts are being made to try to get it right, and that's a longer process, and I would expect that it will be a process that we'll be discussing for many years, simply because the domestic legislative attitudes to insolvency are very different from jurisdiction to jurisdiction. So all it remains for me is to say that I think your session has been excellent, and it has been indeed a testament to what LIW stands for. It's also a testament to what Arbinsol stands for, is trying to create a dialogue. LIDW is a very collaborative process. An event to qualify as an LIDW event cannot be done by any member of LIDW, but has to have a number of partners. And this partnership and this dialogue has been prevalent today. So all it remains for me to say is thank you. Thank you to the audience that have stayed with us for a good 100 minutes, which is heroic at the end of a week, and a week that has been very, very busy with Zoom and other events. So that's well done to the speakers and the moderators. And thank you very much to all of you for attending.
Thank you so much. Thank you so much, everyone. Have a great rest of the week, or rather the weekend. And please stay safe wherever you are, especially a big shout out to people back in India. Please stay strong and please stay safe. Thank you so much.
Thank you.